Hi everyone, and welcome to the Learned Friend platform. Myself, Advocate Retabile Siema.
And myself, Advocate Aurelia Shopsile Ngumalo. A happy Mother's Day to you.
Same to you too, my friend, and happy Mother's Day to all the mothers that celebrated in this blessed day. And a further happy Mother's Day to every person that actually, shares in the sentiments of what is celebrated on Mother's Day. But moving swiftly on, we hope our learned friends have been keeping up with all the relevant COVID-19 regulations, as we saw a myriad of them coming through this past week. And we as the Learned Friend SA platform have also endeavored to at least post on our IG account snapshots of the amendment as and when they come through. But stepping right into the first topic for today's episode, we will be discussing the South African court systems. We love this topic. We love discussing courts. We love discussing judiciaries and on and on and on and all of that. And basically, we'll be honing in on how this pandemic, how this lockdown has affected the judiciary, the legal fraternity at large. So last week we saw a media statement being released by the Minister of Justice and Correctional Services, Mr. Ronald Lamula, where he issued directives for the level 4 in terms of Regulation 4.2 of the Disaster Management Act. In these regulations, he basically outlined on which case the South African courts would have to prioritize, namely your serious violent cases, gender-based violence cases, femicide, your robberies, your murders, corruption, sexual offenses, violation of COVID-19 regulations, and amongst others.
Can I interject? I have a bit of a conundrum because the same week we saw, on the 8th of May to be precise, we saw the presidency tweet that the President, Cyril Ramaphosa, has authorized the placement on parole of selected categories of sentenced offenders as a measure to combat the spread of COVID-19 in correctional facilities. Makes sense, overcrowding, right? So, which are considered high-risk areas of infection, as the President out in terms of Section 82(1) of the Correctional Services Act, which empowers him to authorize at any time the placement on correctional supervision or parole of any sentenced prisoner subject to conditions that may be recommended by the Correctional Supervision Board or Parole Board. So can we then be in a position where we are taking on more prisoners because people don't know how to stay at home and not contravene the COVID regulation? Like we're trying to flatten the curve in SA prison.
Exactly, that's the reality. So, sorry, friend, yes?
Yeah, so we're trying to flatten the curve even in the SA prison. So with the COVID-19 regulations being serious cases that people will still go to prison for or be fined for, do you want to be in a position where you are arrested
and now are detained with serial offenders, right? Is that what you're basically saying, seeing as the low-risk inmates are now going to be released on parole?
Exactly.
Yeah, you know what? This is a great topic. And I think it's actually going to provide us with some great legal content analysis of same, but we are digressing. So can we just go back to access of courts? I'm pulling you back with me to the access of courts. And the Minister of Justice further stated that in terms of the access of courts, insofar as the criminal justice, that access, i.e. Participating in a trial proceeding, would only be limited to those persons that have a limited interest in the case, which I thought was wise to do. And he further articulated that the judicial officer that is responsible for that particular case is now under legal obligation in terms of level 4 to not only reduce, but to ensure that the number of persons in a courtroom at any time complies with the safety measures and the social distancing principle that's been put into place. But what I did think was awesome, if I can just say that, is that the minister also stated that in level 4, the court systems would have to utilize audio-visual links that we find in our courtrooms and our correctional services centers, if they exist, in order for purposes of like postponing a hearing where the accused is already in custody. So, and then he also further stated that if a courtroom or correctional services finds themselves in the instance where they don't have audiovisual links, then they could use other mediums such as teleconferencing, video conferencing. And I thought, you know what, this was a step in the right direction and a great way forward and not further stifling access to justice.
Absolutely.
I also thought that it was great. It was admirable of the minister to put in place this regulation because it speaks to a new normal. It speaks to the fact that we are now part of this fourth industrial revolution, and it's about time that the legal fraternity, the judiciary, actually embasks itself in this technological landscape.
Absolutely. I think it is about time that legal practitioners embrace technology, and I support in principle the call to open courts gradually, or using the phase-in approach as we have seen in other departments, whether it's like education or other areas of the presidency. And understandably, many of the fundamental rights have been infringed by the regulations, and access to courts is one of them, as per Section 34 under the Bill of Rights in our Constitution. So Level 4 is in effect relaxing some of the restrictions, which is great, and thus working towards the right to access to courts and the rights to just, reopening the economy. As it stands, it has been said that the entry to courts is limited. As you said, it's material interest, it's people who are the petitioners, litigants, the accused, and the witnesses. So the court may also allow people accompanying minors, persons with disabilities, and victims of abuse to enter the courtroom. So which is great. I mean, it's a great way forward. And I think it's such a nice, we're seeing a holistic approach, which I really, really do appreciate about what the president is doing now, where it's actually giving reasons behind regulations or reasons behind his actions or reopening all the restrictions, which is great.
And we're also seeing, the NCC via the president also basically endeavoring to balance interests, So without us actually having this unlimited access to courts, we give a limited access, but then we also, protect people's rights to that access as well. And, on the point of minors, the minister also further stated that where children are still detained in these child or youth care centers or in correctional services, then the responsible people are now also under legal obligation to come before the court and make applications pertaining to the further detainment of these children. And he also articulated that there are also child-specific matters that would also be heard during Level 4, namely child and spousal maintenance applications and hearings, protection orders in terms of the Domestic Violence Act and Protection from Harassment Act, our foster care applications and hearings, and any other matters in respect to the care and protection of the child. And, further extending on that, also things like the international abduction of children proceedings would also be heard, and adoption of children application and hearings would also be heard.
Absolutely. And I think he also touched on civil cases that are not identified as urgent, which may not be placed on the court roll, which is, I'm really enjoying what's happening now. And I do look forward to a further breakdown, which I believe will provide more clarity. And also just to be noticed that he stated that all criminal cases enrolled during Alert 4 must be postponed, save for priority cases or trials, as you've mentioned, those taking place within the context of the permitted services stipulated within the regulations, or where special arrangements have been made with the judicial officer hearing the matter. But can we just, go back to the parole discussion? I'm ready.
You love the issue. Really love it. All right. You know what, I really think we should. And I'm also, in terms of this parole issue, I'm elated that the NCC, again, via the president, has, as you said, endeavored to now provide more interest, more background behind these amendments. And insofar as this early parole situation is concerned, the president, articulated that our correctional service centers would now be relieved of just under 19,000 inmates, whereas there's a current population of 150,000 inmates. And I mean, that's a huge number. 19,000 is a big number, but when you put it into context with this 150,000 inmates, we get that context, and as you mentioned, this parole dispensation is only going to be applicable to low-risk inmates and those that have passed the minimum parole detention period or would have passed same within the coming 5 years.
I love the fact that there's the exclusion, which was a little settling because, again, as people, you read a tweet, you read the headline, and you're like, oh my God, drama. Yeah, so now. So this excludes inmates that are sentenced to life imprisonment or serving terms for specified other serious crimes, including sexual offenses, murder, and attempted murder, gender-based violence, and child abuse. So inmates that will be affected by this decision will be placed on parole instead of having their sentences remitted. They will therefore continue to serve their sentence under community corrections until they reach their respective sentence expiry dates. This is in no way a free pass, as offenders may still be arrested and ultimately reincarcerated if they violate their release conditions. So, I mean, I'm really happy for the reasoning. As much as we're still going to get further breakdowns, just the bit that we've gotten just from the presidency with the conditions that are going to be put in place for these release of these inmates is for me settling extremely.
It is settling. And I think we are looking forward to getting, as you said, a more detailed public briefing in terms of these rehabilitation programs that will be put into place, the pre-release programs that will be put into place, the parole placement programs that will also be put into place, and of course, my favorite topic, the access to courts, more detailed briefings on that. And yeah, that's us from topic 1. Please engage us.